Welcome, everyone. My name is Shayna Jacques. I am the outreach manager for PSS Circle of Care. I want to thank all of you to join us today to today's webinar. Okay, so today's title is Top 10 Tips for Executor. Our is Stephenie Yeh. Stephenie, can you hear me?
Yes, I can hear
Okay, great. Her title, she's a senior associate at Lassar Cowhey. Did I pronounce that right?
you. Lassar Cowhey.
Okay, great. So some of you might know a little bit about PSS. Just a quick overview about our services and what we are. We opened it in 1962. We are a multi-services agency who has for mission to strengthen the capacity of older New Yorkers, their families, and community to thrive. Um, PSS has a variety of resources and department where one of them is where the one I work for is PSS Circle of Care that provides free personal support for those caring for someone who's frail, chronically ill, or has a memory loss. We also has um, a grandparent and family member other than a parent that's raising the grandchild. That is the kinship program. Um, our PSS also have a coming of age program that's inspired people 50 plus to live with passion and purpose. We also have senior centers. We have 10 senior centers in all Upper Manhattan and the Bronx for all the adults to stay healthy, engaged, and connected. Today we're going to hear a little bit more about executors. Stephenie Yeh is going to present that for us. If you have any question, you can wait. We can add it to the Q&A box or the chat room, but the Q&A is easier for us. The webinar is been recorded. If you're missing anything, you can go back to our website to view it. If you have any question regarding the presentation today, feel free to contact Stephenie or you can contact me. My name is Shayna Jacques. My email is sdques@spssusa.org. And also we do have a business event. Please visit our website. For caregivers, it's psscaregiver.org. For our coming program is coming of age agency and coming of age NYC, .org. Please visit our website. We do have a lot of event, pssusa.org/event. And also this webinar will be recorded and added to our website.
First, thank you for listening to this webinar, everyone. I want to first thank PSS Circle of Care for hosting. As Shayna talked about earlier, they are a great resource for caregivers in all 5 boroughs. They offer support to family members and friends who may be elderly and or suffering from a disability. She also touched on kinship caregivers. So that's people who are caring for minor children, and those people are not the parents of those children. They also are a great resource for people who want to start their careers in social work. So feel free to explore their resources on their website. So I'm just going to introduce my law firm. My name is Stephenie Yeh. I'm an associate of Lassar & Cowhey. We are a boutique trust and estates firm primarily located in Manhattan. We also have offices in New Jersey and also Long Island. We primarily work with families and business owners. Our attorneys are licensed in New York, New Jersey, and Florida. Many of our clients are high net worth individuals, so that means the planning is focused on estate taxes and income taxes. We also specialize in estate planning, so that includes forming and completing a global estate plan for our clients. So not only drafting wills and trusts, ancillary documents, but also talking about beneficiary designations, reviewing business operating agreements. And like I said, many of our clients are business owners. So we do help our clients establish entities for their businesses. We draft operating agreements, shareholder agreements, and succession planning. So that's really how to move the business forward to the next generation. But today's topic is about estate administration, which is something my firm handles as well. We help guide family members and friends of the decedents through the legal process after someone passes away. So everyone has dealt with death one way or another, whether it's a grandparent, a parent, or a friend. Sometimes it is expected. Maybe the person was older in age or had a long struggle against cancer, but sometimes it's not expected. Maybe there was a car accident or a diagnosis out of the blue. And the difficult truth is that everyone dies. The grieving and coping process that takes place can be very, very difficult for the loved ones of the decedent. So my job, especially for today, is to help you through that process and bring clarity to that. So today's topic is, you've been appointed executor, now what? So today's discussion is really going to break down the process and make it as clear as possible what the process is after someone passes away. There's a lot of legalese and a lot of misinformation out there regarding estate administration, so I'll try to clear that up for you. We're going to start with identifying roles. So who's who in this process? What is probate? What happens if there's no will? The top 10 duties of every executor. Should every executor agree to serve? And we're going to end with everyone's favorite topic, estate taxes. If we have time, I'll also get into some other interesting topics at the end. So, today's webinar is only an hour, and I really can't possibly cover all the topics of estate administration. So the topics not covered today are what makes a will valid, estate litigation, which in and of itself would probably take way more than an hour anyway. So that's will contests, compulsory accountings, forced heirship claims, removal of fiduciaries. We also will not get into disclaimers. So that means when a beneficiary decides not to take his or her share of the estate, they could file a disclaimer. We're not going to get into that today. We're not really going to get into creditors either. So who gets paid back first when someone dies? We'll talk about the creditor period, but not the order of priority for payback. We're also not going to talk about trust administration, but some of it overlaps with estate administration. We're not going to talk about tax court proceedings or ancillary documents, although they're very, very important. Power of attorney, healthcare proxy, living will. We're not going to get into that today. So identifying roles, who's involved? The first person is the decedent. So that just means the person who passed away. That person could also be called the testator if we're talking about the will. So the testator is the person who signed the will. We also have beneficiaries under the will. So those are people who are specifically named in the documents. And we also have beneficiaries of non-probate assets. So I'm just going to break down what probate and non-probate means. So non-probate means assets passed to a joint owner or a beneficiary according to a designation. So for example, that could include an IRA or a brokerage account with a beneficiary designation, or a life insurance policy with a beneficiary there. It could also include real property if it's jointly held with survivorship rights. So those pass directly to the beneficiary or that joint owner. They don't go through probate. So probate assets are really everything else. Any assets in the decedent's individual name with no joint owner and no beneficiary. So that could include a checking or a savings account in the decedent's name alone. That could also include a house. So if the person's house was in that person's name alone, that will be a probate assets. If a beneficiary designation fails, say the beneficiary named on the IRA is predeceased the decedent or is otherwise unable to receive those assets, that's also going to be a probate asset. So when we talk about probate assets, that means that all of that will fall under the will if there is any. So it's really important to know that when you sign a will, that's just one part of an estate plan. You might sign the perfect will for yourself with all these subtrusts for children and grandchildren, but if all your assets are non-probate assets, your will could be worthless. So it's important to talk to your trust and estates attorney and for them to get a really global view of what your estate plan is. Next, who's involved? Distributees. So those people are people who would have been beneficiaries of the estate if the decedent did not sign a will. So that could be spouse, children, it could go down the line. And it's important to know that those people might not be the same people as the beneficiaries. And we'll get into that a little bit later. So continuing who is involved. Next is fiduciaries. So you have the executor of the will. So that's the person who the testator decided to manage the estate and distribute the assets. If there's no will, we call that person an administrator. There's also trustees if there are trusts involved. And there are also guardians if there was a guardianship involved with the decedent. We also have the surrogate or the judge. So this is the person who ultimately oversees the estate. This is the decision maker if there are any disputes among the beneficiaries or with the fiduciaries. And then next we have the advisors. So attorneys. There could be many, many attorneys involved with an estate administration. There could be attorneys for the estates, attorneys for each beneficiary, attorneys for the distributees, attorneys representing the trust. So you really want to make sure you know who the attorney represents, and it may not actually be you. Next, we have accountants, so CPAs. These people will prepare the income tax returns, and we'll get more on that later. And finally, we have financial advisors. So these people could have been involved with the decedent during the decedent's lifetime. So they manage their investment accounts. They could also transition to assisting the executor or administrator with the investments owned by the estate account. So their relationship could be ongoing. All right, next. What is probate? So probate is really the method by which you prove to the court that the decedent's will is valid. If there's no will, we call that administration. So it's either probate or administration. It's important to know that not every death will then require a probate or administration. Sometimes you can skip probate and administration completely, even if there is a will. So there are key questions to ask. You have to find out, are all assets jointly held or have a designated beneficiary? Are all assets in the trust? And if the answer is yes, you might not need to go through the court process at all. Next, what if there is no will? So just a refresher about probate and non-probate assets. Probate assets will be governed by the laws of intestacy, and that will vary state by state. Non-probate assets, so those are assets that will pass by contract or beneficiary designation because there's a joint owner or beneficiary on there. Those will pass directly according to that designation. So getting into the New York laws of intestacy. So what happens if a New York resident passes away without a will? And like I said, it varies state by state. Some states have different rules based on whether there's children of the marriage and children not of the marriage. There's different proportions and percentages. So you really want to make sure you're looking at the right state when you're looking at these rules. So in New York, if someone dies with a spouse and no children, the spouse get everything. If the person died with a spouse and at least one child, the spouse gets the first $50,000 plus 1/2 of the remaining estate, and the balance go to the children. And if there's more than one children, they just divide it equally. If there's no spouse, the children get it equally. If there's no spouse and there's no children, then it goes down first to the parents, then the decedent's siblings, and then to nieces and nephews. Now, what happens if there are no people involved like that in the decedent's life? What happens, unfortunately, is it does pass to the states. So if you want to make sure that your assets don't pass this way, you need to act affirmatively. So say you have no spouse, no children, no grandchildren, but you have parents who you're not in touch with or siblings who you're not in touch with. They may be the one inheriting your estate. So if you don't want that to happen, you have to take steps. What steps can you take? You can designate beneficiaries on your accounts. You can sign a will and or a trust. You just have to take incentive to avoid the intestacy rules altogether if that's not how you want your estate distributed. All right, I'm just going to go through a good example of what can happen if there's no will. So you may remember a woman named Flojo. So she was an Olympic sprinter and she set records in the late 1980s. She was nicknamed the world's fastest woman. Unfortunately, at age 39, she suffered from an epileptic seizure and died. Her family swore she had a will. They searched and searched. Unfortunately, they couldn't find it. Now, the mom claims that her daughter promised her that she could live in the couple's apartment rent-free for the rest of her life. Now, what did the husband think? The husband disagreed completely. They got into very, very heated estate litigation, and it was between mother and son-in-law. So really, the ultimate goal of every estate plan should be to avoid disagreements among family members. You want to avoid estate litigation. It can be costly, and the family tension can be very, very strong. So what are things that Flojo could have done to avoid this altogether? She could have signed a will and made sure her attorney kept it for her in their safe. She could have let everyone know what her wishes were, including her husband, get the husband on board, and maybe give mom a life estate in the property. So it's clear that she wants, and maybe the husband too wants the mom to live there for the rest of her life. Now, it's a really, really difficult situation because no one would expect a 39-year-old to die, especially not an Olympic athlete at such a young age. So it's really important to plan no matter what your age is. Now, going through an executor, whether it's an honor or a curse, it's a huge responsibility to undertake. It's a position of enormous trust and confidence. You're expected to manage the estate assets properly. So that means paying legitimate debts and expenses, making sure the estate assets are invested properly. So maybe that means contacting a financial advisor, distributing assets according to the will. And you're really not an executor until the testator dies and you're appointed. So just because you're named under someone's will, while the person's living, it doesn't mean you have a role yet. It is a really difficult role, especially because it takes effect when emotions are very high among the family members and friends. And that's when someone passes away. A lot of times the family is held together when the matriarch or the patriarch is alive, but after they die, siblings start to fight. It's not a thankless job. There are commissions. So the commissions are either whatever the testator said they will be under the will, or it could be statutory. So in New York, we look to Surrogates Court Procedure Act 2307 to look at how the commissions are calculated, and it's an equation based on what's in the estate. Now, top 10 duties of every executor and administrator. The first duty is really an information gathering duty. So that's the first phase. What the executor or administrator wants to do is collect certified death certificates. You want at least 4. Now, you really want more if the decedent had accounts and assets at different financial institutions, because each institution is going to want their own death certificate. You also need to collect burial and funeral receipts. And the important thing is to show that it was paid in full, because that's what the court is going to want to see. You also want to collect family information. Who are the children? Who is a spouse? If there are children who predeceased the decedent, did they have kids? Who are those kids? Are they minors? Is anyone a person with a disability? So you want to make sure you collect that information when you start with an estate. You also want to collect asset information, whether assets are probate or non-probate. You want to collect account statements, statements of life insurance policies, and also, importantly, beneficiary designations. You want to collect deeds. You want to collect information about any valuable, tangible property. Maybe the person had fine china or jewelry or artwork, and it might become really important as the executor or administrator to marshal those assets. So we're going to get more to that later. Oops. One last thing for collecting documents and information. One of the most important things is also to collect testamentary instruments. So that means original wills, trusts, beneficiary designations. You're really required to make a diligent search of original wills. And there might be more than one original will out there. And you want to make sure you find the most recent one. And that's the one that's going to be probated. You also want to find out whether there are any living trusts that the decedent signed during his or her lifetime, whether they're revocable or irrevocable. And you also want to find out what beneficiary designation information you have. If no will can be found, you would file an administration petition, and you do need to attest to the court that you made a diligent search for the will and none could be found. The next step is really to spread the news. Notify the right people. So the executor or the administrator should let Social Security Administration know that the decedent has passed away. This is so that their Social Security payments, if they were receiving any, can be stopped. You also want to let Medicaid or other government agencies know. So if the decedent was receiving government benefits, you want to let the agency know so they can stop those benefits. You also want to start contacting interested parties. So if you go through probate or administration, they will need to be formally given notice, but it might make sense also to start reaching out and collecting contact information for these people. If there is a guardianship, it's important to note that you do need to notify the court examiner and the court, and you do need to file certain documents to close the guardianship. So that all needs to happen while you're starting the estate side. One important note to make, if you want to avoid credit card scams. So unfortunately, there are people out there who look through obituaries and they look for really important information like the decedent's name, their address, any other identifying information. And then they go and set up these credit cards under this dead person's name. So in order to avoid these scams, it is recommended that you send copies of the death certificate to each credit reporting bureau. So that's Equifax, Experian, TransUnion. You want to make sure that each of these bureaus places a deceased alert on the credit report. So if there's anything that pops up afterwards, there will be an alert. You also want to contact the DMV, have the DMV cancel the driver's license. And this is really just to avoid anyone going in and claiming to be that deceased person and getting another ID. You also want to check credit reports. So make sure yourself that there's no suspicious activity, there's no new accounts being opened that you didn't know about. All right, step 3 is filing the right forms. So each state has its own forms. Even the counties within New York State have their own little ways of handling estates. So it's best to really check with the court what is required. And the court that you check with is the court of the decedent's county of residence. And in New York, we call that surrogate's court. You want to have the original will, if there was any. You want to have a certified death certificate, copy of paid funeral and burial bills, and court fees. So depending on the size of the estate, that's what the court fee will be to administer the estate. So in New York, the most it will be is $1,250, and then you pay per certificate for every letters that you need. All right, step 4 is really to just secure the assets. So once you receive letters, you're officially authorized to represent the estate. So what that means is you want to obtain a federal tax ID number. We also call that an EIN. You want to open an estate account with that EIN number and with your letters in hand. You're really responsible for securing and marshaling the decedent's assets. So what does that really mean? Physically, that means securing the home, making sure that if it's a home that no one else is living with, that you're watching over it, making sure no one's trying to burglarize the home. If it's personal property, like we talked about the artwork, or maybe the person had valuable jewelry at home, you want to make sure that's secured as well. Financially securing assets means contacting credit card companies if you haven't done so already, letting them know the person has passed away, checking insurance policies as well. Next, you really want to identify all the decedent's assets and then transfer all assets into the estate accounts. Now, this could take a very long time depending on the number of institutions you have to work with. Each institution will require at least a certified death certificate and original letters. So depending on the institution you're working with, it could take a long time for their back office to review the documents and approve it. So you want to make sure you start this process as soon as possible. You also want to gather financial statements. So that includes account statements, tax returns. This is the time to get the CPA involved. So the CPA will need to file a final income tax return for the decedent and also check to see if there are any tax returns that the decedent did not file that may need to be filed later. You also want to determine what the date of death value is for the assets. For certain assets, especially if there's real estate involved, you may need to get a certified appraisal. So it really depends on the situation, but if you plan to sell the property right away, soon after the person passes away, you could just use the sale price when you're filing the estate tax return, but it really depends on the situation. All right, next step, the fifth step, is to check for debts and creditor claims. So I mentioned the creditor period briefly earlier. Creditors have 7 months from the issuance of your letters to file a claim. So it's not 7 months from the date of death. So if you drag your feet because you think that the decedent had a lot of debts out there, that's not going to help strain this creditor period. It's going to be 7 months from the issuance of your letters. And during that time, you are required to keep the estate open. So what that means is you have your estate account. You cannot distribute all of the funds to the beneficiaries yet. You have to keep it open and wait for creditors to make their claims. So during this process, you also want to pay any legitimate debts of this estate. So you want to review any claims there are from creditors, including medical expenses, credit card bills, income taxes, mortgages, and real estate taxes. So 6 through 9, we're just going to breeze through. These are all filing requirements. So the first is file a final income tax return if required. So if the decedent had any income in the last year of his or her life, a tax return may be required. So you also want to check, like I said earlier, check to see if previous income tax returns were filed. So this is something that your CPA will help you with. You also want to file a final estate income tax return if the estate had any income. So after you set up the estate accounts, if that money was then in a brokerage account and that brokerage account rendered income, maybe a lot of income, you want to make sure that the CPA handles the estate income tax return as well, and you make sure that any income taxes are paid before you pay out all the beneficiaries and the creditors. The 8th step is to file an estate tax return if that's required. So this is typically handled by either the estate attorney or the CPA, but I'm going to make a very biased recommendation that the estate attorney handles this. This is because the estate attorney was involved with the estate from start to finish. They're familiar with the estate assets. They know the people involved. They know the families. They know the dynamic between the family members. So they're already familiar with it. So in my opinion, they're the best people to handle an estate tax return. Now, whether an estate tax return is required or not, we're going to get into that later when we get into the slide about estate taxes. The 9th step is to file an inventory of assets and liabilities with surrogates court. So this is required by New York surrogates courts, and you can contact them for a template. And this just lets the court know basically how much was collected, how much was paid out in terms of liabilities, and they also want to make sure that you paid the right fee. So if originally you estimated the estate to be much smaller, but it ended up to be much more than you thought it was going to be, your fee might be higher. So the court wants to make sure that they get the difference in those fees. All right, the 10th step is just to wrap it up. So that means preparing a final accounting. So who can help with this? This is the CPA or the estate attorney's job. You want to really include in the accounting what assets were collected, what was the value of each asset, what were expenses that the estate had to pay out, what is income that the estate collected, what are all the taxes owed as part of the estate and what was paid out, were there any interim distributions made? So that just really means were beneficiaries given a distribution from the estate before the estate was ready to be distributed out and concluded. You also want to look at, you also want to include whether there were any commissions owed, so to the executor or to anyone else, and how much was paid. Now, accountings can be formal or informal. What formal means is that you have to go through the court. So you file an actual accounting with the court and the court oversees that process. Informal means you don't go through the court. Now, whether you do formal or informal, it really depends on the estate and the beneficiaries. If you've had beneficiaries who've been fighting from the start, and this estate is extremely complex, and maybe it's gone on for years and years, and you just know that the beneficiaries are going to contest and not agree to an informal accounting, you might want to just go through court to make sure it's settled judicially. Why would you want to do it informally? Well, it's much more cost effective to do an informal proceeding. So if you're able to do an informal proceeding and get the beneficiaries to agree, maybe everyone's pretty friendly for the most part, you would prepare the informal accounting, still including all the information we talked about, and send it out to the beneficiaries. So you also want to include a receipt and release if you decide to do an informal accounting. Now, this is not required by any means, but it is best practice to include it and get the beneficiaries to release the executor. And this receipt and release is an agreement in which the executor lays out exactly what happened throughout the estate, how much was collected, how much was paid out, what debts were paid. And you really want the beneficiaries to sign that agreement because that relieves you of liability. So it says that the beneficiaries agree that everything you have done so far has been by the book, everything you have done has been by the best interest of the estate, and that they release you from liability. Lastly, you just want to supervise the distribution of assets. So like I said, if there is any of that valuable artwork or that jewelry, you want to make sure that goes to the right people, and you want to make sure it's distributed to the right entities if there's entities involved. Now, a really good question to ask, should every executor agree to serve? And the quick answer is no. It's completely optional. It's not required at all. Now, it is a lot of work. As you saw, steps 1 through 10, it's a lot of work and it can be very, very time consuming. And if you are working a full-time job and you have other obligations, maybe you're a caregiver yourself, you might not want to take on this responsibility because it's a lot of, you're required to do a lot. Some necessary skills that you want to have is you want to be detail-oriented, you want to be organized, you really must be honest, you want to be as transparent as possible with the interested parties, the beneficiaries. You also need to be really, really patient because you're sort of in the middle, especially if you're not one of the beneficiaries, you're in the middle of all the intra-family conflicts. So the siblings fighting that we talked about, you're going to be in the middle of all of that. One really, really nice thing to know, though, is you're not alone. You can get help from professionals. So we talked about attorneys, accountants, financial advisors. Seek the help of these people, especially people who are well-versed in the trust and estates world, because they're going to help guide you through this process. The fees are usually paid from the estate funds. So it's not like you have to shell out the money yourself. As long as it has to do with administering the estate, it's an estate expense and can be paid from the estate. Now, if you are the primary beneficiary, you actually have an incentive to serve. So you have an incentive to make sure that everything is done correctly and timely. No one is delaying things that shouldn't be delayed. You can push financial institutions to approve the documents and approve the transfer to the estate account. So you have a huge incentive to serve as an executor, as long as you have the time and the means to do so. And let's not forget commissions. So like I said, executors, it's not a thankless job. You are entitled to receive commissions, and they're based off the statutory equations if the testator did not say otherwise. One thing to realize, though, for commissions is if you do decide to take it, and you have every right to do so, you do have to declare on your personal income tax return. So you do have to pay taxes on that. So that's one big catch. Now, everyone's favorite topic, estate taxes. So we're going to talk about federal estate taxes first. So they're due 9 months from the date of death. You can get an extension to file, and that extension can be up to 6 months. But you cannot get an extension to pay. You have to pay the estate tax by the deadline, the 9 months from the date of death. So even if you need more time to collect all the supporting documents to put with the estate tax return, you just need to pay the tax owed. And if you don't pay on time, the Department of Taxation will issue, it will charge you interest and penalties on that unpaid amount. So that's really important to know. Right now, the federal estate tax landscape is very, very high. It's 11.4 million per person. And if you're a married couple, you get to share in that. So you get to share 22.8 million. So that's really, really, really high. We haven't seen it this high ever. And the rates can be as high as 40%. But with 11.4 million to work with, not a lot of people have the great fortune of having a federal estate tax issue. Now, this law does sunset in 2026, but we all know that it may actually decrease earlier. And the reason being is the 2020 election coming up, and depending on which way it goes, it may result in a decrease of federal estate taxes sooner than 2026. Now, trust and estates attorneys and others who practice in the sector, we all have our prediction of what's to come, who's going to win the election and what's going to happen to our estate taxes. But the truth is, we really don't know. The most that we can do as attorneys is to form estate plans that have flexibility that evolves with the changing estate tax threshold. So whether it goes up or down, it's important that your attorney crafts language to deal with the changing numbers. All right, for state estate taxes, it's important to know not all states have an estate tax. Some states that don't include Florida, Delaware, Arizona, California, although I just read that a senator announced a proposal to bring back estate taxes in California with an exemption amount of 3.5 million. So that's much less than what the federal limit is now and what we were before the tax change. New Jersey also doesn't have an estate tax, but there are some caveats with that. They do have an inheritance tax. So that means that if you are not a Class A beneficiary, and they define Class A beneficiary as a spouse, children, grandchildren, or people down the line, then there will be an inheritance tax. Also for New Jersey, there are talks of bringing back the estate tax. So there has to be lots of flexibility when we're planning with New Jersey residents. And fortunately or unfortunately, if you reside in New York, there is an estate tax. Right now it's 5.74 million, and there is a cliff. Now, what that cliff means is if your estate is between 5.74 million and 6.027 million, only the amount of your estate that exceeds the 5.74 million will be subject to tax. Now, if we call it falling off the cliff, if your estate is past 6.027 million, you have fallen off the cliff, and the entire taxable estate will be subject to New York estate taxes. So that's really important to know where you stand on that spectrum. It's also important to know that there's no portability. So that means that benefit that we get with federal estate taxes, where you get the full 22.8 million between married couples, you don't get that for New York, and you don't get that for most states. I think the only state that offers portability is Hawaii. So because there's no portability, if there is an estate tax issue between, and it's a married couple, we're dealing with spouses, you want to make sure you have certain provisions in the will to make sure that the married couple can somewhat share the unused estate tax exemption. So some extra credit here. I touched on this earlier before. It's really very important to understand who the attorney represents in the estate administration. Who is the attorney's client? So if you're the executor and the attorney is representing the estate, that is your attorney. That attorney is representing you and the estate. If you're a beneficiary, the estate attorney does not represent you. The estate attorney represents the estate as a whole, not each individual beneficiary. So if there's an issue and you're a beneficiary and you don't like how the executor is handling the estate attorney is not going to help you. You are going to have to probably get your own attorney to represent your interests. You also want to look for ways to avoid beneficiaries fighting. So you want to look out for sibling rivalry, any complicated family dynamics. But really, whose family isn't complicated? And like I said earlier, whenever a parent or a grandparent passes away, that's usually the time for sibling tension to come out of the woodwork. You really want to rely on your attorney, and I mean your attorney. You want to disclose to your attorney everything you know about the family, the beneficiaries, the assets. Give your attorney time to spot and anticipate potential problems before they become really big problems. The sooner your attorneys know about these potential problems, the better. That way they can anticipate and plan around that. You really don't want to hide the family secrets from the attorney. Let them be let them offer you that safe environment for you to air out your concerns. And my last slide is about the importance of planning. So we talked about what happens if you don't plan. I wrote an article with Lassar Cowhey, a partner of the law firm, and it's titled Tidying Up Your Estate Plan So Your Loved Ones Won't Have to. So the point of that article is really to take the burden off your family members by taking initiative to plan early during your lifetime when you can. You can find that article on the New York Law Journal website. It was published on September 2019. I also want to get into the case of a famous musician with no estate plan. So some of you may have heard of Prince. And when Prince passed away, he had nearly $200 million plus royalties. It's been 3 years since his death. And unfortunately, his heirs still did not receive a single distribution. Prince left absolutely no estate plan in place. So he had no will, he had no trust. So his estate was held up in really, really extensive litigation. First, many came out of the woodworks claiming to be heirs of his estate. So some people claim to be children. I read of one case where a man in prison actually claimed to be the son of Prince. So that really held up the estate. Finally, they determined that Prince died without any children. He had no spouse. So his 6 siblings would be inheriting his estate. Unfortunately, like I said, there's still no distributions to the siblings. There are ongoing issues with regarding taxes and the IRS and deciding on the valuation of some assets. So that's still ongoing. So like I said, it's been 3 years since his death. I would say for such a big estate, and especially one so complicated and one with no estate plan in place, that is probably not atypical. You do see really complex estates going on in the court system for many, many years. So, I mean, the end result for Prince's estate is they've racked up $45 million in expenses. So that includes $10 million in legal fees, and that's just so far. So like I said, it's still not wrapped up yet, so the fees will continue to be ongoing. So really the takeaway here is you really want to avoid estate litigation as much as possible. The reason being is you really want to reduce legal fees because with estate litigation, there's going to be legal fees involved. You also want to plan so you can avoid estate taxes. So the takeaway here is really to speak with a trust and estates attorney, learn how to devise the right estate plan for you and your family. So not just a will and trust, but looking at the beneficiary designations and what your overall goals are. You want to also avoid family conflicts and litigation. Like I said earlier, letting your trust and estates attorney know if there is potential for your children or for your siblings to fight over your estate at the end of the day. And my last takeaway is to sign ancillary documents. So that includes power of attorney, healthcare proxy, living will. I know we didn't get to that today. That could be another hour in and of itself, but those documents are so important for every single person to have. And if you wait too long and God forbid something happens and you no longer have capacity, you don't have the opportunity to sign these documents anymore. And the result might be a guardianship. Okay. And that's all I have. Thank you, everyone.
Thank you, Stephenie. I think there's one question. If you see it, the webinar will be recorded and posted on our website. It's up to you, Stephenie, if you want to share the slide, but like I said, it will be recorded and posted online. We cannot send the recording individually, but it will be also available for everybody to see it online. But
Yeah, and I'm happy to share the slides. I put my contact information on this last slide,
Mm-hmm.
my email information, as well as my phone number. So if you have any questions or any concerns after this webinar, feel free to reach out to me. And if you want a copy of the slides, I can send that as well.
Okay, great. So reach out to Stephenie if you want the copy of the slide, and then the recording will be online on our website. Any other questions? You can use the Q&A box to add the questions. And okay, one question. Thank you, Jim. I'm glad it was very helpful for you. Okay. Stephenie was really great information for everybody. I think it was so clear, so no anybody has question. If you have any other question regarding anything that Stephenie presented today, please reach out to her. And if you know of anybody that in need on our service from PSS, please reach out to me. We are here for everyone and help them to find any resources in the community. And help the caregiver relieve some stress by looking around for information. Please reach out to me. My name again is Shayna Jacques, and my email is sjacques, JACQUES @pssusa.org. Again, Stephenie, thank you.
Thank you so much, everyone.
Thank you. And I'll talk to you soon, okay?
Okay, thank you.
And have a great day, everyone.